actually will give me a little bit of time, because I think you'll probably do some setups.
Yeah. Well, I'm gonna, hit a number of cases really fast. Anyone you want to jump in on, you'll set you up.
Perfect. Yeah. No, that's fine.
Okay, good afternoon, everybody. My name is Bryan Dearinger, and I'm an assistant clinical professor here at the law school. And I have the good fortune of being able to moderate our third panel today. This panel concerns two U.S. Supreme Court cases decided during the 2023 October term that really are all about presidential power. To discuss both of these cases, we're super fortunate to have with us two of my colleagues, Stuart Chinn and Garrett Epps, and I want to just briefly introduce each of them. Stuart Chinn is the Frank Nash Professor of Law here at the University of Oregon. He writes and teaches about constitutional law, legislation, legal and political history, and American higher education. His book, Recalibrating Reform, The Limits of Political Change, was published by Cambridge University Press. He's published in peer review venues such as the University of Chicago Press, Law and Social Inquiry, and Polity, and more broadly in a number of top law reviews, including Wisconsin Law Review, Maryland Law Review, Utah Law Review, and the University of Pennsylvania Journal of Constitutional Law. Garrett Epps is a professor of practice here at the law school, where he returned from a stint at the University of Baltimore School of Law. Before heading east, Professor Epps taught con law here at Oregon Law. And while at Baltimore, he served for 10 years as the Supreme Court correspondent for The Atlantic, publishing more than 400 essays analyzing the Supreme Court's evolving constitutional jurisprudence. His book, To an Unknown God, Religious Freedom on Trial, is a detailed history of the Employment Division versus Smith case, the famous peyote case decided by the Supreme Court that originated here in Oregon. And like Professor Chinn, he has published in top law journals, including the Duke Law Journal, North Carolina Law Review, and American University Law Review. So what I want to do quickly is just set the stage for our panelists by briefly summarizing the two cases about which they'll make their remarks and answer questions. And that's sort of how we'll do it. I'll introduce both cases. The professors will make remarks about both cases, and then we'll open it up for questions, okay? The first case is Trump versus Anderson. And if you remember, that's the presidential ballot case. And so just briefly, the legal question presented in that case was whether a state could use Section 3 of the 14th Amendment to disqualify presidential candidate Donald Trump from appearing on Colorado's 2024 presidential primary ballot. And back in December of 23, the Colorado Supreme Court did just that when it ordered the Secretary of State to remove Trump from the Republican primary ballots, citing Section 3. The court, in a per curiam opinion this past spring, reversed that decision by the Colorado Supreme Court, holding first, while states have the power to disqualify state officials under Section 3, they lack the authority to enforce Section 3 against federal office holders. The second thing the court decided in that case is that Section 3 of the 14th Amendment requires specific legislative action by Congress before an office holder can be barred for running for or holding an office. There were two concurring opinions in the per curiam opinion, and I'm sure we'll get to that later in the panel. The second case is Trump versus the United States, and that's the presidential immunity case. The question presented in that case was whether and to what extent a former president enjoys presidential immunity from criminal prosecution for conduct alleged to involve official acts during their tenure in office. In a 6-3 decision, the Supreme Court ruled in favor of former President Donald Trump in this case. And it made three holdings. First, it held that a former president has absolute immunity from criminal prosecution for actions that occur within their, quote, conclusive and preclusive constitutional authority. Second, the court held that former presidents have at least presumptive immunity for all other official acts. And third, the court held that there's no immunity for unofficial acts, although the court did not really define that term. By no surprise, there were multiple concurring and dissenting opinions, and I'm sure we'll get into that. That's a brief summary, and from there, I'll turn it over to my esteemed colleagues, starting with Professor Epps.
Thanks, Bryan. I definitely want to talk about those two cases. They're very important and revealing. I think more so, if I can take a little time to put them in the context of a really bizarre term in the life of the Supreme Court. It's been my custom over the years, for various journalistic reasons, that you write an essay at the end of the term, and you say, here's what happened this term, and here's what we need to watch, and so forth. I did that for this term, but it took me until last week because it was so hard to piece together any coherent thought. It's a little bit like trying to critique the wallpaper in a house that has just been blown up by a 2,000-pound bomb, or you sift through the rubble to try to find how they decorated the house. And I think that it's important to understand that these two cases occur within the context of what I consider to be almost terminal institutional multiple organ failure. The Supreme Court is in a death spiral. It's just amazing how badly things have gone, how fast, since they were remodeled by the Trump administration. But we have a court now that is so internally incompetent that it can't even conduct an investigation. You remember they announced they were going to do this great investigation of who leaked, and then at the end they said our results of our explanation are nothing. It does not have sufficient internal culture to avoid members of the court engaging in flagrant violations of a judge's duty of impartiality and even of financial probity. You've got judges taking money. A generation ago, would anyone have thought this would happen? It has become a leaky vessel, which the court never was before. But if you think back to the trend since 2012, the OT 211, if you will, with the leak of the deliberations in the Affordable Care Act case, that has become increasingly the norm rather than the exception of the court. And I think in a weird way, it's perfectly justified because the court is gradually becoming a super legislative body. And if you live by politics and policy, you die by it too. I mean, both the presidency and Congress are very leaky, and this is now overtaking the court. The other thing, of course, is that the court, with a great deal of bravado, has now announced that it's in charge of a wide variety of federal policy, and they did that in part in an opinion in which we learned that none of the 9 justices or of their 37 so learned, impressive clerks knows the difference between a deadly pollutant and laughing gas that you take at the dentist. It was quite a remarkable display. I think that the institution is adrift. I think that the people on the inside are very concerned about its future, and I think that it's very hard to understand some of the major decisions that they engaged in without placing it in that context. Institutional terror, but it is also a thoroughly politicized court, and I think that to the extent that it can, the court will intervene in political processes to boost the chances of the Republican ticket. And so these two things are going on. It's torn, letting I dare not wait upon I will, as it waits to see the outcome, just like the rest of us, of the presidential election. Now, I think these two dueling impulses explain the two once seemingly blockbuster abortion cases that came before the court, which the court engaged in transparent evasion to avoid deciding on the eve of the presidential election. I think members of the court have been shocked by how negative the reaction to Dobbs was, and I think Dobbs has a lot of language praising the court for its own courage, but I think they thought maybe they'd take a little hit for a few weeks and then people would get over it and return to giving them the adulation they think they deserve. That has not happened. The Dobbs decision has changed our politics across a wide variety of races and is the chief threat to ongoing Republican domination of our politics, and I think that gave them a lot of pause. And so when you think about the Alliance for Hippocratic Medicine case, in which the court dismissed a challenge to the FDA approval of mifepristone on the grounds that these particular plaintiffs did not have standing to challenge. But Justice Kavanaugh drops a very interesting Easter egg in the end of his opinion, saying, of course, we're not saying that some other people might not have standing to challenge, and this is a direct quote, the FDA's relaxed approval procedures. So there's a hint that they think they should get involved, but not in an election year, of course. And then the other case, which is called Moyle versus U.S. or Idaho versus U.S., two consolidated cases, about whether the Emergency Medical Treatment and Active Labor Act superseded Idaho's sort of total ban on abortion, and that has no exception for health of the mother. The court heard oral argument. They had intervened and taken the court away from the case away from the Court of Appeals because it was so urgent, had to be decided right away, heard oral argument, and then issued an opinion saying, well, you know, we kind of thought about it, and we just don't figure you guys really have much of a quarrel. Why don't you just go work it out? We're dismissing the case as improvidently granted and send it back to the Court of Appeals where they had taken it as an emergency case. And I think that it's hard to, you know, I actually, believe it or not, I try to be charitable, but it's hard to see these as anything but attempts to avoid a headline, you know, court bans abortion more. And after the election, we will see these issues come up again. That brings us to the two cases Bryan mentioned, you know, Trump versus Anderson, in which the Colorado Secretary of State, interpreting Section 3 of the 14th Amendment, said Trump was not eligible to appear on that state's primary ballot. The court swooped like an avenging angel on that case and granted cert almost within hours of the decision by the Colorado Supreme Court. They had expedited briefing. They had oral argument as soon as oral argument could be heard. They issued an opinion within a few days. And of course, that had the result of restoring Trump to the ballot and sending the word to states that they could not exclude him from either the primary or general election ballot. Then we have United States versus Trump, which is a case in which President Trump is being prosecuted by the Justice Department for his actions in the January 6th matter and you know, the near lynching of the vice president. And that case didn't seem to need quite so much haste. Hold on now, Hoss, let's think this one over. And so there was a long delay before they granted cert, and then they offered a long period of briefing and put the case down for decision on the last day of oral arguments, and issued an opinion, you know, later in June, in which they basically said that the president is immune from almost any criminal prosecution, and if you think you've found something he's not immune for, you can make a motion, but then he can appeal to us, so that we will see these immunity questions coming up over and over if Trump is not elected. And, you know, why would the court be afraid? Why would the court? Well, I think it's important not to underestimate the extent to which all of the federal establishment has been intimidated by the Trump movement. And this court, in its heart, you know, the majority urgently favor a return to power of Trump, but they're also a little worried about what part they're supposed to play in a MAGA world. And I think that one of the most interesting passages in United States versus Trump was this. The Chief Justice Roberts writes, virtually every president is criticized for insufficiently enforcing some aspect of federal law, such as drug, gun, immigration, or environmental laws. An enterprising prosecutor in a new administration may assert that a previous president violated that broad statute. Without immunity, such types of prosecutions of ex-presidents could become routine. And this you, I think, have to understand within the context not of Jack Smith, but of the open avowal of Trump that he will put Joe Biden in jail if he becomes president. And I think the court is desperately trying to send a message that, you know, don't bring this stinker to us. We don't want to be part of it, whether it's someone prosecuting you or someone else prosecuting Biden. The other thing that I think is on the justices' minds is that the court is now so deeply unpopular. It's in a trough of popularity it has never seen before, except perhaps in 1936. And the result is that danger surrounds it on both sides. Now, very striking development in the news is that Joe Biden, who of all people, all actors in that political elite, was the most profoundly committed to doing nothing about the Supreme Court, was most profoundly committed to a traditional view of the role of the court, and, you know, appointed a commission to investigate exactly all the ways that we could not do anything about the Supreme Court, which it did, has now called for Supreme Court reform. That's how far things have gone on one side. So the court has to think that if Harris and Walz and Democrats are returned to power, there's going to be there might be a credible assault on the separateness and independence of the court. But that doesn't mean that it's okay if they don't win, because a new Trump administration is equally a danger to the independence of the court. Let's always remember that when Trump decided to call out the Chief Justice on his Twitter feed by name, he put independent judiciary in quotes. He ridiculed the very idea that courts are independent. And we also know that the Trump administration openly flirted with defying the court on the census case. They were prepared to pretend to be complying with the court's order, but actually just blow past it because Trump felt strongly that this should be on the census form. And we then have his vice presidential running mate, the ever popular Mr. Vance, who said in 2022, that Trump should put himself above the court. He said, "I think what Trump should do, if I was giving him one piece of advice, fire every single mid-level bureaucrat, every civil service in the administrative state, and replace them with our people. And when the courts stop you, stand before the country," and he's quoting an apocryphal statement attributed by Andrew Johnson, say, "The Chief Justice has made his ruling, now let him enforce it." So we are, what happens in November, we are sailing into untried territory. And the court feels, I think, intensely exposed. I kind of described their posture at the end of the term as fetal position, just sort of whimpering and saying, "Leave us alone." When people or institutions are fearful, even the wise act like fools. And the court's opinions signal a willingness to do what it takes to win Trump the presidency. Bush versus Gore too. I think we know how that would come out. But also a desire that whatever nefarious schemes of revenge and change might dominate a second Trump term would not involve the court, right? As they've worked to clear obstacles from Trump's path, the court is also begging for mercy. Whatever you're planning, Mr. Trump, leave us out of it, Please, just leave us alone. To which I say, good luck with that.
Well, thanks, Garrett, for that. I have some observations that are probably going to align with what you mentioned just now. I want to run through the two opinions in a little bit of detail and then offer a couple of broader thoughts on the other side of that. With respect to Trump versus United States, so there's this framework set forth in the majority opinion by Chief Justice Roberts, which seeks to differentiate levels of criminal liability and thinking about unofficial versus official acts, and then thinking about the difference between core presidential powers versus non-core powers. And I'd submit that there's nothing, I mean, it's not the style of analysis I would choose, but there's nothing necessarily in those categorizations or in those descriptions that's necessarily problematic. What really sort of emerges as a problem is how you see the court gives content to that framework and how it seeks to apply it. And I think there's enough evidence later on in the opinion about just how broadly they would apply this framework to basically provide a criminal immunity for presidents that will cover basically everything, right, as the dissent by Justice Sotomayor notes. So consider in this regard two questions. How do we classify unofficial versus official acts, and how do we classify core versus non-core powers? Well, official acts happen to be interpreted by the court very broadly. And to quote them, they say, quote, for those reasons, the immunity we have recognized extends to the outer perimeter of the president's official responsibilities covering actions so long as they are not manifestly or palpably beyond his, in bracket, authority. And then furthermore, in talking about what official conduct entails, it makes it clear also that courts can inquire into president's motives, into a president's motives, because doing so would, quote, or such an inquiry would risk exposing even the most obvious instances of official conduct to judicial reexamination on the mere allegation of improper purpose, thereby intruding on the Article II interest that immunity seeks to protect. And so you can see how these sorts of arguments set up a pretty favorable terrain in terms of the court's assessment of the events that are under investigation with respect to Trump. So, for example, in talking about Trump's conduct in trying to enlist the Department of Justice to help him with his claims of electoral fraud in 2020, Roberts sees this as official conduct. And more than that, a core presidential power, because this implicates the president's power, the executive power to investigate. And so he says Trump is absolutely immune from prosecution for this conduct. And like many others, I find this more than just slightly problematic, right? And more on that in a minute. What about Trump's behavior, his efforts to enlist the vice president to allegedly fraudulently engage in altering the electoral count? And Roberts tells us that whenever the president and vice president discuss their official responsibilities, they engage in official conduct. So again, broad category applying there. Now, the court also does note that this is not necessarily a core matter. This is a situation where there's just simply a presumption of immunity and not absolute immunity. And the reason for this is because the certification of the election implicates congressional power. So Roberts says, district court, look further into this. What about the allegation of Trump's efforts to organize fake slates of electors that would support him in the electoral count? The Supreme Court punts on this and says, quote, we accordingly remanded the district court to determine in the first instance with the benefit of briefing we lack whether Trump's conduct in this area qualifies as official or unofficial. But, for most of us thinking about that, it seems pretty clearly that this should be held subject to some kind of judicial process because it looks very illegal. And then finally, the court addresses Trump's various statements surrounding January 6th, and the court also tries to back away from any clear statement about this and says that it will be for later judicial process to figure out how much that counts as official versus unofficial conduct. So let me flag two last items from the Roberts opinion before talking about some of the other opinions. Roberts is certainly aware of the critique of this opinion that with it, he's elevating the president above the law. And he offers one not terribly convincing argument on the other side, but he offers this point that he's like, well, presidents still subject to criminal liability when they act in their unofficial capacity. But again, given how broad that definition of official acts is, that's going to be a very, very small category behavior that's going to be covered. And the second is, he says this point, which is worth pondering. It's, if written by a different person, different opinion, I would take it a little bit more seriously. But he does offer this point that the president is sort of situated differently from everybody else, and thus that's what accounts for this sort of heightened criminal immunity from criminal law, because the president alone is a branch of government. And then Garrett mentioned this point, but I'll reiterate it here. There's also this prominent nod to pragmatism. He sort of gives voice to the concern, I'm taking him at his word, he gives voice to this concern that anything less than the sort of robust immunity offered by the court majority in this opinion would create huge incentives for successive presidents to seek to pursue criminal charges against their predecessors, and it would just sort of give rise to an increasingly unstable governmental structure. I'll say more about that in a minute. The Barrett concurrence I found quite interesting. I thought Barrett basically concurs with the sort of conceptual framework offered by the majority, but I think there's evidence in her opinion that if she was writing the majority opinion, it would be a little bit more acceptable, because there she's quite upfront in saying that this effort by Trump to sort of organize fake slates of electors is clearly unofficial conduct and should be subject to judicial process. And then we get pretty strong dissents from both Sotomayor and Justice Jackson. So there's this really strong disagreement that the president should enjoy such a broad immunity from criminal law. I think Sotomayor is going to have the better argument on the historical merits. The framers would not have been thinking so positively about a president that was a quasi-king. That was a huge part of what animated the thought around the framing era. She's got a good argument with respect to the text. And Sotomayor accurately points out to the fact that if you sort of follow the logic of the majority's opinion, it sort of inevitably leads to this conclusion that almost anything that you could think about that a president might do that is illegal is going to be covered by some form of this immunity argument, either because the court will classify it as an official act or it will hold it within its core powers. The court makes this point that in talking about how potentially expansive core powers might be, it references the take care clause and the expansiveness of that within Article 2. And the dissenters are just contemptuous of this claim that prompted some disagreement between the majority and Justice Barrett about whether evidence from a president's official acts could be used to support criminal charges for unofficial acts. The court majority said no, that it couldn't, and it did so to sort of ensure the integrity of this broad immunity it wanted to set forth. But Justice Sotomayor offers this hypothetical of the hitman, and so I'll just quote this a little bit at length. Quote, imagine a president states in an official speech that he intends to stop a political rival from passing legislation that he opposes, no matter what it takes to do so, which would be the official act. He then hires a private hitman to murder that political rival, the unofficial act. Under the majority's rule, the murder indictment could include no allegation of the president's public admission of premeditated intent to support the mens rea of murder. That is a strange result, to say the least. There's another interesting hypo put forward by Justice Jackson that I'll mention in a second as well. So, quick summary of the Trump versus Anderson opinion, again, just covering some ground that Garrett already mentioned, and Bryan as well. We have this per curiam opinion. The court agrees that Section 3 is not going to allow states to be able to disqualify candidates for federal office under Section 3. The court then sort of gets into a more detailed analysis about how Section 3 could possibly be enforced, and it makes it clear that it can only be enforced under Congress's Section 5 authority under the 14th Amendment. The dissenters and Justice Barrett kind of agree with that conclusion, that states are not able to enforce Section 3, but Justice Barrett takes note of her difference of opinion, and the dissenters say so with more emphasis or more emphatically, that they're annoyed by this additional step taken in the per curiam opinion to say that legislation under Section 5 is the only route to enforce Section 3. The dissenters say, actually, there might be opportunities for judicial enforcement of Section 3 or congressional enforcement of it through other statutory means. Okay, so let me just offer a couple of thoughts about these two cases, and then we'll be able to get to some questions. As I said before, I don't know that I find the conceptual framework offered in Trump versus United States to be inherently problematic. In the hands of a different justice applied differently, it could be salvaged. Of course, the most troubling signal of how the court's applying this framework is that it reaches this conclusion that Trump's discussions with the DOJ to investigate allegations of voter fraud was absolutely immune. Now, I think what the court majority would say in response to that concern is to say, well, what if there was a legitimate, I would say I don't think there was a legitimate concern of voter fraud, right, in the 2020 election. But majority might say, suppose there actually was a legitimate concern of voter fraud, and an incumbent president decided that they had a duty to investigate. Court majority would say, would we want the next president to then take legal action claiming that their predecessor was engaged in a conspiracy to commit election fraud? And the court would sort of offer this view that it's almost impossible for judicial process to ascertain the difference between a relatively more impartial administration of justice and an instance of naked presidential self-dealing. But of course, the argument put forward by the dissenters, and one that I would agree with, is that the courts in the legal process are capable of this. And that's precisely what the government argued in this case. But stated otherwise, and this is a point raised by Justice Jackson in dissent, there is something very odd about how the court majority decided to approach this case. It's a completely formalistic opinion. And what I mean by that is, if you happen to be a fan of or remember the cases from the pre-New Deal era, this is what the pre-New Deal court was criticized for, was to engage in formalistic reasoning, right? They sort of got into these definitional word games of what was commerce. Was it manufacturing, was it not? And the critique of the legal realists at that time was to say that these opinions had no sort of grip on reality, right? They were just sort of engaged in these abstract theorizing things. And that's exactly what this opinion looks like to me, right? To get into these interesting distinctions between what counts as core or non-core or official versus unofficial, it seems to be missing the larger sort of functional question right in front of the court because it's going to hide behind the definitions. So compare an alternative way a court could have approached these questions. This is what Justice Jackson urges in dissent. Start with the presumed applicability of the criminal law to everybody. And then, if there are good reasons for government officials to have defenses for allegations of violating criminal law, let those be aired out in court. Or here's another one. What I find to me the most glaring problem with the court's majority opinion is the absence of any concern at all for presidential self-dealing, which is a concern we should have for any institution of government, the possibility of naked self-dealing. The court doesn't want to get into that analysis, right? They would be skeptical of getting into an analysis of self-dealing because, as Robert says in his majority opinion, the court shouldn't get into any kind of analysis of presidential motives. And presumably, one of their concerns about this is that, well, potentially anything a president might do could be self-dealing, because most presidents who are in a first term are trying to get reelected. So in theory, anything they do to try to get reelected could be an instance of self-dealing. But, I mean, again, I think this is being a little too quick to abandon the project. Do we really think it's impossible for a judge and jury to be able to tell the difference between a desire to be reelected versus a naked instance of self-dealing to try to basically invent, concoct false evidence of electoral fraud? Do we think it's impossible for the judicial process to differentiate between those two things? I don't. I don't. And so an alternative version of this opinion would have been one in which the court could have thought and theorized a bit more deeply about what kind of self-dealing could allow a president's actions to cross the line into a violation of the criminal law. Another point I would mention about this opinion is that it's really apparent in Roberts' majority opinion, he's deeply concerned about this idea that the president is going to be weakened by the prospect of continual litigation. And even if a president is immune from criminal charges while in office for official conduct, that president, if they thought that there was going to be liability after they left office, might make decisions that are sort of less vigorous because of this worry of liability hanging over their heads. And I find this fixation on presidential weakening to be so completely off-key. When I was in law school, it was in the aftermath of some of the Clinton stuff. And this was a dominant theme from my common law classes about Clinton versus Jones and about how the president could be weakened by all these lawsuits that would divert their attention, which Roberts gives voice to in this opinion. But fast forward to several decades now, is anybody really that worried about the president being too weakened in our scheme of government? I mean, it's gotten out of control in terms of the imbalance within the separation of powers. The president has become a more and more imperial institution. There's no sign of that stopping or being restrained in any sort of way. So this idea that we should be terribly concerned about a weakened president strikes me as completely not aligned with reality. And then the last thing I'll say about this case is to go back to this point about norms. I think the most sympathetic thing I can say for the majority opinion is that it is concerned about preserving norms, as is the dissenters. They're just focused on different norms. The majority is concerned about preserving this norm that we're not going to have successive presidents prosecuting their predecessors. And it worries that if it issues a sort of less robust opinion, that the door to that is open. The dissenters are concerned about a different norm, right, which is the norm of presidents engaging in blatantly illegal behavior to hold on to power, right? Both norms are important. The fact that they're both maybe under stress is indicative of the moment that we're in. But I think the majority could have written a better opinion by not signaling its interest in such a broad immunity for Trump, and by, I think, being a little bit more sensitive to what I think, as Garrett was saying, which I would agree with, is the norm that seems to be under greater risk right now, which is the risk of a president doing illegal things to stay in power. On Trump versus Anderson, just a couple of quick comments. I mean, I think this was the right decision. Uniformity that would be lost with state-by-state enforcement of Section 3 would be a significantly huge problem. To the extent that people thought that the courts, the federal courts, were going to save Democrats from a hard election, they probably were not thinking hard about political reality. There was no way this court was going to take Trump off the ballot in any sort of way. And furthermore, it would have been a huge problem for democratic process and democratic legitimacy, I would maintain. So the court reached the one and only real outcome that could have been achieved in this particular case. But juxtapose that case, that instance, which we might call maybe a moment of judicial modesty, maybe, where the court's saying we're going to try to step out from deciding a presidential election, with the opinion in Trump versus United States, where, I mean, I could see Roberts, if he's trying to defend his performance, would say that it was an attempt to engage in judicial modesty, trying to get the courts out of this, like adjudicating what counts as legal or illegal for presidential behavior. I would maintain that what the court needed to do in a case like Trump versus United States was not modesty. I think more precisely, what we needed there was a court attuned to political realities, attuned to structural weaknesses in our constitutional government, and clear-eyed about where the primary threats to the system we have are greatest. The court had its eye trained on the threat of partisanship run wild, with each successive president prosecuting their predecessor. That's not an invalid concern, but again, I would maintain that the bigger concern in this case with this defendant at this moment in time is a president engaged in naked self-dealing. And we needed a court that was willing to be forthright in grappling with that problem. And it was not this court.
Okay, great. Thank you both. We now have about 25 minutes for questions. If audience members have questions, feel free to raise your hand. For folks streaming online, I think you were able to type in questions in the chat, and we're tracking that. We're monitoring that chat too. So yes, please raise your hand, and so we can get your microphone. And if folks run out of questions, I have a few that I could ask.
I've heard of the debate clause immunity in the Constitution, but is there any Article 3 or Article 1 or Article 2 other immunity? I mean, I'm just perplexed entirely by the idea that we would have a complete Supreme Court decision about immunity when there's no immunity granted.
I mean, the court would say, right, which it talks about, I mean, a huge part of presidential immunity is going to be structural, right? It's sort of inferred from the separation of powers. I think there's some reasoning to support that from earlier cases like Hughes versus Nixon. Is it as expansive as this court said it was? I definitely don't think so.
I think it's striking that in fact, and Sotomayor points this out, that the Constitution discusses immunity at two places. One is a limited immunity given to legislators, right? And the other one is assuring the people that there is no immunity. For someone who is impeached, they can still be tried elsewhere. So, at no place do you find them saying, total immunity is a good idea. But I think the other interesting thing about these two cases is that this is a court that, when it suits its purpose, thumps its chest and says, we are thoroughgoing originalists. We believe only what Madison, or what Kavanaugh rather sneakily now calls the three giants of constitutional interpretation, Madison, Marshall, and Scalia. We believe, that only in their thought. But if you look at these two opinions, there's not a shred of originalism in it. They are pure, as Stuart says, pure pragmatism. They could both have been written by Justice Breyer's evil twin. And, the one thing they say in United States versus Trump is, there's a bunch of stuff out there, historical stuff. We can't make any sense out of it. Let us screw that. And so they just move on. In Trump versus Anderson, you had this background of two of the real adornments of the conservative legal movement, two of their most brilliant and popular scholars, producing a 130-page study, originalist study of the Section 3 question, and producing, they're just saying there's no question that Trump is ineligible to return to the White House. And again, the court just blows past that without even nodding to these two people. So originalism is in an interesting state at this moment.
I think it was Justice Sotomayor. I think it was. I think it was Justice Sotomayor in one of her last dissents in what was a series of really controversial decisions by the court, who basically said the court is just shaping society by brute force, if I recall correctly. Mm-hmm. To what extent, looking forward, do you view the blowback to these series of decisions, Bruen, Dobbs, Trump versus U.S., as having chastened perhaps at least the more centrist members of the court, Kavanaugh, Barrett, Roberts, going forward?
Oh, sure. So yeah, Garrett talked a little about this, and I was thinking about this while he was talking. I mean, I think, to concur with a little bit of what Garrett was saying before, I can't imagine that this court is looking forward to some of the very clear kinds of Trump-related litigation that's going to happen if Trump is reelected. They can't be looking forward to some of those controversies getting in front of them. At the same time, the level of tone deafness of this court with respect to institutional relationships is quite striking. I mean, maybe that doesn't make this court unique, right? I think this court is motivated, or it seems to be motivated by at least these two things in some combination: a great devotion to its causes and a great deal of judicial arrogance. I don't know that those things are unique, but what makes it particularly striking and maybe playing out in distinctive ways is that they are faced with no credible threat from the other branches of government. And so maybe they're beginning to internalize some of this blowback. Maybe they're surprised by the level of vitriol they're getting on some of these decisions, and maybe that will have an effect. But I was thinking about this analogy. I don't know if it quite works, but I think about the court in some ways as kind of like, like one of those animals that evolves on an island without any natural predators, and it sort of just goes about its business because it's never actually faced an actual threat. What makes things healthier for a court that actually enforces a kind of institutionalism and modesty is the belief that there is a credible threat if they step out of line. And this court has not faced a credible threat from Congress or the president, probably going back, I would say, to maybe the late 70s or something, right? So, yeah.
Can I just add to that? I think that a majority of this court remains committed to the overall culture war project, and we will see that recur as time goes on. But they're also committed to and quite welcome to engage in blatant manipulation of process in order to achieve or avert political damage. Let me put it that way. And going back to before Dobbs, you may remember Dobbs was supposedly relisted 15 times while the court was supposedly making up its mind whether to take this case, and there were good reasons why they might not have wanted to take the case. But in fact, we now learn Dobbs had been granted in about the third or fourth time that it came up, and then at the suggestion of the ever-helpful Justice Kavanaugh, the court just pretended it hadn't granted, just kept saying, falsely putting in the U.S. reports, relisted. And that was even before Dobbs. And I do think they were very much taken aback by how prolonged negative reaction to Dobbs was. Is that going to lead them to repent? I tend to think not. I think that, what you see in those two abortion cases that in this term, which is blatant evasion, simply means they'll get to it later. I think there are at least 5 people completely committed to this. And Chief Justice Roberts, I think, who, I used to describe him as Ranger Smith on Yogi Bear. He was always trying to keep the bears from stealing everything and not seeing the humor in all of Yogi's antics. But I don't think so. I think he's taken his uniform off, and he's one of the 6 now. And we will see them press forward. I think they're daunted, but they're not giving up.
Just to follow up on the comment about court reform, over the past year, 2 things really stick out of my memory. One is the Chief Justice refusing to testify in the Senate about some of the payments and gifts that various justices had received. And the other one, I think, was about a year ago when Alito said, I'll say it, that there's nothing in the Constitution that says Congress has any authority to regulate us in any way, period. And I just wondered if you had a comment on those episodes.
Well, there's a third key event. I mean, I think you're right to foreground those two. But the third key event is the issuance of this so-called code of ethics, unenforceable, and apparently the justices aren't going to abide by it anyway. But as somebody, my colleague Rob Wolf pointed out in the Washington Monthly, the court blinked for the first time in Roberts' tenure as Chief Justice. The court blinked. The court gave a little bit. The court said, well, I won't testify, but here, this may keep you happy. And I think that once they've taken that first step, you know, we're in a kind of stochastic process. We don't know where it'll end up, but they are not successfully defending the Alito position anymore, I think.
I'll sort of add, you know, in terms of the content of the reform ideas, you know, term limits, I think it's a great idea. You know, we've seen Ruth Bader Ginsburg's reputation take a little bit of a hit in terms of how things played out with respect to her departure from the court when she passed away and so forth, and people talking about whether that retirement decision should have happened a little bit earlier. The dynamics that are sort of surrounding this are getting more and more ridiculous and dysfunctional. This whole like appointing people in their 30s to the appeals court so they can get to the court earlier, right? All this stuff, as opposed to, you know, the old idea of appointing people who had were distinguished and had a lot of experience. The age game's gone out of control. I've talked about this a fair amount in my classes too. This whole thing about waiting for people to die and how all of a sudden our government's going to shift, it's like, you know, reminiscent of like living in a monarchy or something. It makes absolutely no sense. Ethics code, of course, makes a lot of sense too, but I think, you know, these reforms that we're talking about, I'm not holding my breath that they're going to happen anytime soon. I don't, you know, I think the court is starting to internalize maybe some of this blowback, but do they feel they're under threat in the same way the court felt under threat in 1936? No, they don't. I mean, what would get this court's attention if, you know, is if a governing coalition won like FDR won in 1936. That would definitely get its attention, but we're a long way from that.
If Trump v. Anderson gives us this notion of uniformity across states in federal elections, how do you square that with last month's RNC v. Mi Familia decision, where despite the National you know, Voter Registration Act setting out the guidelines for qualifications, the court deferred to Arizona's rules, that are more restrictive. You know, it seems like that is going against the idea of uniformity. Or is the court just kind of making up stuff as it goes along?
Well, certainly the latter. The question is, you know, can you see a principal difference between the presidential ballot, right, which is what Trump versus Anderson is concerned with, and the general federal ballot, over which states are explicitly in the Constitution given some authority? You know, including the selection of electors. Each state shall select in a manner the legislature thereof shall determine legislatures, and in terms of legislative elections, the states are explicitly permitted to conduct them as they see fit unless Congress regulates them. Now, this court is interpreting the regulatory part of that very narrowly, and it's been part of a general hostility to voting rights legislation that we've seen at least since Shelby County, if not before. I think that voting rights are in serious trouble in front of this court, and but I do think there's some textual thing for them to hang their hat on there.
I have a question. So as scholars and teachers of constitutional law, how does your view or the way you teach the Nixon case change, U.S. v. Nixon change after Trump v. U.S.? Of course, particularly in light of the Trump v. U.S. ruling about the, as it pertains to the use of evidence in official acts. Nixon was about the privilege. Mm-hmm. Trump is, U.S. is about immunity. Does Trump v. U.S. gobble up, does privilege gobble up, or does immunity gobble up privilege? And how do you view that, and how do you plan to teach it? Nixon case.
So, I mean, I think on the surface of it, this court majority would say that their opinion is aligned with Nixon, because I think they would say the threat in Nixon, which was seeking, or the question in Nixon, seeking evidence that was in the president's possession, is maybe less of a threat to executive power than an actual criminal prosecution. The court also cites the Nixon in talking about a structural-based executive privilege that aligns with what it's trying to say here, which is a structural-based criminal immunity. But, I mean, I would agree with the Sotomayor dissent that this case is clearly in tension with the Nixon case. It definitely cuts against it, and I think it probably represents a bit of a paradigm shift in presidential power, because I would argue core to the Nixon opinion is this belief that the president is subject to the general applicability of the criminal law, and it seems like this opinion is very much going in a different direction.
Yeah, I sort of feel like we're never going to see a headline that says U.S. versus Nixon overturned, but we are liable to see some fairly extravagant interpretations of what material is privileged from congressional investigation. And remember, the Trump administration, at least in its last 2 years, took the position that it didn't have to comply with any request for information, never mind testimony under oath. So we will see, I think, U.S. versus Nixon not overturned, but made much wider. And the other thing that's interesting about Nixon versus U.S. is that it had to do with a district court issuing a request for information. Judge Sirica, the hanging judge. And what has now infected the court and shows up in U.S. versus Trump is a deep distrust of the lower federal courts. This court regards everyone in the government except itself as an idiot or a knave, and you can see this in the Justice Department argued, I thought, fairly cogently in U.S. versus Trump that this is not going to be an out of control phenomenon, because in order to prosecute a president, a prosecutor will have to decide that doing so is consistent with his or her oath of office, and then has to present to a grand jury. And the court basically just says, a grand jury will indict a ham sandwich. Who cares about these lower courts? They're just out of control. And that was a theme you saw developing throughout the Trump administration, the so-called theory of the judicial resistance, that lower court judges were acting in an illegitimate way because they didn't agree with the MAGA program. And only Justice Thomas, who's kind of the id of this body, actually put that into an opinion in the census case, where he just said, this lower court judge was just going to find against the president no matter what, and his factual findings are entitled to no clear error deference. So I think that would complicate if the same issue came in front of the court. Again, they might find a way to just blow out the whole thing by saying that the lower court hadn't behaved properly.
Also, just add to this too, I mean, think about this case, we saw with the Dobbs case, right, this sort of crystallization of certain thoughts that have been running within conservative legal movement for a very long time, and it was just finally, there it emerged, right? I mean, the conservative legal establishment's been talking about the unitary executive for a really long time, and maybe this is, the final, or the ultimate, the mature crystallization of it, and also maybe a moment as well for, a chance to sort of fundamentally reassess it in a way I think people will reassess originalism in the aftermath of Dobbs.
The other thing to know about this court, which I think no other court in history has had this characteristic, is that 6 of the 9 got to the bench by service to the president in the executive branch. Yeah. It used to be that you would be a distinguished judge somewhere, and people would say, learned hand, we definitely need you, or whoever it might be. Not now. You work for the president. Kavanaugh, for God's sake, was not even a legal official in the Bush administration. He was staff secretary, directly political, handling all the internal deliberations of the White House. These theories of extravagant executive power flow from that. They would have gotten laughter, even under the Burger Court. So that's something to keep an eye on, and it's very worrisome.
That's how I actually understand or think about Roberts' role in this too. Roberts is interesting for a number of reasons, but despite how he can take this sort of moderate position or be the institutionalist in certain contexts, there's a handful of these issues where he seems like a true believer, and I think he's a true believer on the unitary executive stuff.
I think so too.
I just want to encourage your writing and research to look at what appellate courts are doing in their disrespect with regard to district courts and how they're taking the bull by the horns, and when they see a case that they want something different and sending it back, instead of sending it back to the district court to develop the record or to look for the facts, they're just substituting, or they're just taking the position and running with the case. So I think that's a trickle down from higher up in terms of the disrespect, but I also think that that's going to blow up the entire system in terms of how things function, because there are no records, there are no facts.
I think that's a very good point, and I think that if you want to imagine the future with a reelected Trump and his stamp further on the judiciary, just look at the Fifth Circuit, which essentially now is a law-free zone. They just do whatever they want, and when lower courts, district judge in Texas, district judge in Mississippi made a decision, preliminary decisions in an abortion case. They just reached down and they issued an order that the judge could no longer consider anything about the case, and then just took it away and wrote, in my opinion, that the opinion in those cases is what, if you speak Yiddish, you would say it's a bissel meshuga. It's just like crazy opinions, because they figure there's no one to stop them, and the other thing is they want to jam up the Supreme Court. They want to throw these cases on the court's doorstep that the court will have to take because the lower court ruling is so extreme, and maybe cut back a little bit on it, but still move the ball in the right direction. So I think you make a really important point. And I haven't studied any but the Fifth Circuit. I've followed them with horrified fascination, in part because one of my law school classmates is one of the chief evildoers, but that's a different story. But I think that we will see that spread if there are more appointments by a Trump administration to the circuit courts. And by the way, Trump has said that he said about his judicial appointments, I'm coming back and no more Mr. Nice Guy. I don't care what the Federalist Society thinks. I don't care what the Heritage Foundation thinks. I'm going to put people on the court that I like. He may appoint Ivanka to the Second Circuit. So we should really be. There's a kind of chaotic instability that is creeping into the system at all levels, and it's very worrisome.
I'm curious if you think that there's any conclusions that can be drawn on the court's potential view on another undeveloped area of law from Trump v. U.S., and that's what their views might be on the ability of litigants to hold the president directly liable for civil violations of the Constitution.
For official acts or something, or what are we talking about? Or
Yeah, I think there's zero.
yeah.
That's Nixon versus Fitzgerald.
Yeah.
And in that case, in Nixon versus Fitzgerald, it was a meritorious case. I mean, Ernie Fitzgerald was a guy who really was treated very shabbily. But the court said, I think with some reason, look, if we do this, anybody, can get a lawyer somewhere, Lionel Hutz or somewhere, and sue the president, and the president will be doing nothing but answering suits about his official capacity. The argument was made in U.S. versus Trump that there is much more of a filter through the criminal prosecution system before such a prosecution can be brought against the president. So, Nixon versus Fitzgerald may be troubling, but defensible, I think.
And also the harms too, right? The harms contemplated with a criminal trial. It's the harm against the public, not just against the individuals. So it's different stakes too.
Yeah.
There was a question online. Is there anything preventing future presidents from invoking Trump v. U.S.?
Preventing? Preventing them?
Invoking it.
Oh, anything? I'm sorry, can you repeat the question?
I think preventing future presidents.
From
what are
invoking.
the implications for future presidencies?
I think the restriction, if any, on the exercise of presidential power is going to have to be political.
It's a political cost, yeah.
The way it is in a lot of other issues.
Cost.
And that brings to the foreground and subjects to some concern Mr. Trump's statement that if everyone will get out and vote for him this time, they won't have to vote again. So that there is a project on the right of freeing government from any kind of political accountability. That's what the political gerrymandering cases are about. And that's what the attack on the ballot is about, attempts to restrict the ballot. And that's, you know, what some of this stuff is about. It's worrisome.
I mean, maybe, so, you know, playing out hypotheticals, let's say there's the second coming of the progressive era, right? And people, like, there's a whole line of party politics around good government and morality or something. Then, yeah, you know, like, invoking this as a precedent is not exactly burnishing one's credentials in that department. And so, yeah, you might weigh cautiously into trying to, you know, get in line with this because it might cost you some political credibility with certain constituencies.
With that, I think we're out of time. Please join me in thanking our panelists.